So, as healthcare professionals, our primary responsibility is to care for patients with skill, compassion, and integrity. However, in today's medical practice, even with the best intentions and highest standards, unforeseen situations, complications, or misunderstandings, they can lead to legal claims against the doctors. This is where indemnity insurance becomes a critical safeguard. It not only protects us, the doctors, from the financial and legal consequences of such claims, but also ensures that patients are compensated fairly in cases of proven negligence. In other words, indemnity insurance helps balance patients' rights with professional security. Now, which one to buy and which are the ones which completely cover all our interests as doctors? In today's session, we will discuss what indemnity insurance is, why it is increasingly important in medical practice, how it works, and what are the key considerations for us when we are choosing a policy. So, by the end of this class, we will understand how indemnity insurance is not just a legal formality, but an essential tool to practice medicine with confidence and peace of mind. In the series of Kanoon ki Pathshala at NIGF, we have started these series to safeguard our interests. And the first one is how to protect ourselves financially when we are in a case. So, to uh, have our session today, we have none other than our Fevicol, Dr. Sharda Jain ma'am. She is fondly known as teacher of teachers, and she is ma'am, you are the one because of which we are all here. Thank you very much for joining, and we all know you very well, and we are here because of only and only because of your hard work. Dr. Ragini Agarwal, a very decorated senior with so many fellows, so many fellowships, so many accolades, so many
बस शकुंतला बस
to her credit, and she is the one who's the president of NIGF right now. And because of her, we have had so many branches now, which are like working so nicely. Our very own Dr. Gaurav Agrawal, very well known in the accolades of the TGF Kanoon Ki Pathshala, where he has enriched us with his knowledge. He is a doctor as well as a lawyer. He is a panel medical investigator to a national level medical insurance company, medical legal advisor, and many more. So, sir, welcome you as a speaker for today's session. We have our experts, Dr. Kiran Chandna. She is Director, Chandna Medical Center, Faridabad. Has had several honors and awards and achievements to her credit, with special interest in MTP, contraception, and adolescent health. Welcome, ma'am. Dr. Rimi Singla. She is Medical Director, Radiance IVF and Radiance Hospital, Mohali, Punjab. President Mohali OBGY MOHOGS, Secretary of HISAR Chandigarh. She has several credit, faculty credits to her accolades. She's won several awards and achievements, and has been a technical education minister of with the Punjab. So has been awarded several excellence awards and has been emerging leaders in IVF in the region by the Indian Health Council Delhi. That has been the award she has been given. Welcome, Dr. Remy. Dr. Vidhu Modgil is from Director and Senior Consultant, Suman Hospital, Ludhiana. She is obstetrician gynecologist par excellence with several credits to her accolades and has a lot of credits to her achievement. Welcome, ma'am, to this session. So, without much delay, I hand over. Just a second. Without much delay, I hand over the whole session to Dr. Gaurav Agarwal for his deliberation. Thank you very much, Dr. Gaurav, for accepting our invitation.
Dr. Shakuntala, I would like just to have some words from Madam Dr. Sharda Jain before starting the session for her kind words for the
Before
today's
starting the
topic.
session, yeah, ma'am.
The topic has been suggested by Dr. Sharda Jain only.
I think congratulations, Dr. Sangeeta, for starting this particular session. Little glitches are there. But I think, we have been having insurance for a very, very long time. But what I find, towards the end of my career, I find that insurance has been taken, but somehow the indemnity insurance have not been able to help us, whether to have a lawyer or, pay off the things. They say, जब आपका केस सेटल हो जाएगा तब we chip in. So I think we are absolutely lost and seated. We would like to hear from Dr. Gaurav Agarwal. After having indemnity insurance for the last 35 years, at least I am not benefited. Though I have taken an insurance of a 1 crore of rupee, but somehow we are not helped out by anything. So we will love to be tutored today by Dr. Gaurav Agarwal, which kind of insurance people should be taking and what all. So they are helpful to us and not, just for taking sake, we take the insurance. So over to you, Dr. Gaurav Agarwal.
Thank you, ma'am. So, can you see my screen now, full screen?
Yeah.
Okay.
I
Thank
think
you,
as
ma'am.
per Roshan, this much will be only.
It is not full screen, sir. इसको
Ma'am.
full करना पड़ेगा.
This is
Slide share करके.
Roshan says this is full screen, but this is the best you can see in this application. Am I right, Roshan?
Yes, sir. Yes, sir. Yes, sir. We can watch the Google Chrome. We will develop app, then we can get the full screen.
Okay. So from my end, it is full screen, and apologies for whatever. Even I have faced a lot of problem, but there I durust hai. So greetings of the day, my dear sisters and brothers. This issue of indemnity. What we realize, if I would summarize before commencing, would be that as Ma'am Dr. Shada Jain rightly said, that you've been paying premium for 10, 20, 30 years, and at the end of the day, when the court says, okay, your insurance company will pay on your behalf, the insurance company, this is an increasing trend nowadays, my dear friends, that they file an affidavit in the court saying that we are not liable to pay. And the doctor is shocked after 2, 3, 4, 5 years of litigation. Why the hell will you not pay? I've been paying you premium religiously on every date, every year. So they say, and they list out, not one or two, but at least 5 or 10 reasons in a 5 or 10 page long affidavit. These are the reasons that we do not owe any liability to you, and you will have to pay from your own pocket. So, if fresh litigation starts against the insurance company for pressurizing them to pay up on your behalf. So, with this brief, you know, I'll be talking about professional medical indemnity insurance policy for doctors. Mind you, this professional indemnity insurance is for all professionals, and it is the same ditto policy whether it is an advocate, a MBA professional, or even maybe an architect. It's the same policy for everybody. What is indemnity? Indemnified or indemnified means it means to insure or protect against loss, damage, or injury, or to give something in order to make up for loss, damage, or injury. Now, see this picture carefully. You can see you as the doctor on left side of the screen. In your left side, the patient is besides you. So, if there is a error in judgment or alleged medical negligence, and you want to protect yourself regarding that, so for that treatment that you administer to the patient, you pay a yearly amount to the indemnity company called the doctor's indemnity company, and he assures you that he will protect you against any medical negligence or error or omission during your treatment. So, medical indemnity, as far as law is concerned, it is a contract of indemnity, and it is, we did LLB, now we're doing LLM. So, it's a part and parcel of the Indian Contract Act 1872, much before independence it came in, and it is the same as been followed by the Britishers, especially Section 124, and it talks in detail about indemnity, the person who is indemnified, the indemnity company, and all the contracts. So the entire contract of indemnity insurance is made out under Section 124 of the Indian Contract Act. What are the objectives? Are to protect the professional interests of the insured doctor, to indemnify the doctor in respect of any claim on ground of professional negligence or misconduct, to arrange, conduct, and pay for the defense of the doctor.
Dr. Gaurav, your slides are not moving.
Oh, really? I can see them moving. I don't know. Roshan, can you help me over here?
Yes, sir.
Yes,
Yes, sir.
now they are moving.
But you must be seeing a smaller field now.
Both fields.
Okay, I'll continue with that now.
Mm.
So I'll just quickly recapitulate. So professional medical indemnity policy for doctors. Indemnity means to insure or protect against loss, damage, or injury. Look at this picture: doctor, patient, and indemnity company. So the indemnity company is indemnifying you for any damage that might occur to the patient during your treatment, and it is under 124 of the Indian Contract Act. These are the objectives, as I mentioned. And so the important thing to notice that the advocate charges and everything, litigation charges, everything is also funded by the insurance company itself. But everybody knows how their attitude is. They are just copy paste, very young advocates, hardly able to give personal attention to doctors. I would say more on that. So coming to, so I've divided this presentation two parts. First part is a very brief part, about only 4 or 5 slides about the indemnity. Okay. The next part is how insurance companies deny you, on what grounds they deny, and how to protect ourselves from denying the coverage that is due to us if awarded by the court in favor of the patient and against the doctor. So as far as premium is concerned, this money talk is important because somehow many times this discourages doctors from taking up a higher premium. So for a surgeon or dentist or a gynecologist, it is 200 rupees per lakh. So for example, if you obtain a cover of 2 crores, the premium is 40,000 rupees only plus GST. And by the way, the 22nd September onwards that the GST was supposed to go zero on health insurance, it has gone zero only on health insurance, okay, and not on indemnity insurance. So GST of 18% remains the same. Okay. For physician, it is much less. Who are not dispensing, only rupees 50 per lakh. We optimally recommend that they can have a premium of coverage of 1 crore rupees. For any specialist physician or cardiologist, at least 2 crores, just like any surgeon. Plastic surgeon, the rate is 300 rupees per lakh. So, if you have got unqualified staff, for example, compounders, etc., assistants in your medical establishment, we recommend that you register them as well. Because अगर उनकी कोई गड़बड़ हो जाती है, it is just like error and omission policy for the hospital. So, if they make a mistake, then you can claim in regard to that as well. So, for example, if you got two unqualified, I have listed out an example. Total premium amount 40,000, for example, 2 crore for gynecologist plus 6,000 rupees. That is two staff multiplied by 7% of 7.5% of the total. Okay, plus 18% GST. So the total comes for 2 crore premium per annum 54,280. But you don't have to, in all circumstances pay this. You pay only less than somewhere around 22,000. So the discount which almost every company is giving nowadays is at least 60% on this, which is not available on most of the insurance products that are there in the market, whether it is life insurance, mediclaim, motor insurance, fire insurance, or anything at all. So with this background, I'm going to talk about in detail how indemnity insurance companies befool you and how to outsmart them. That is the exclusions of the indemnity insurance policies and uh, the reasons that they're going to say that we do not owe you any money. For example, let us assume the insurance court awards 50 lakh rupees. If the insurance company says you will have to pay from your own pocket, doctor, we don't owe you anything. So this is about a comprehensive look into common reasons how indemnity insurance companies befool you and deny your claims despite indemnifying you for medical negligence errors for so many years. Why you will have to pay from your own pocket when the court orders lakhs to crores of rupees in compensation to the patient and things. I always recommend, as far as the question which insurance company to go for. So as far as insurance companies, there are private sector and government sector. In the government sector, or the uh, there are four companies: National Insurance, New India, Oriental, and United India. I always recommend to go for these companies because private companies, I worked for Star Health Insurance as a panel medical officer for 1 year. I've seen that when it comes to granting money, compensating the patient or the insured, then they behave as if you are asking them to donate blood or you committing a theft in their company. And the attitude of government insurance companies is okay. What have got to be to lose? It's the government who is paying. So their attitude is perceptionally starkly different. If you talk to your insurance agent, they'll guide you about. So I'm taking some examples for most of these issues. For example, read this question carefully. A doctor was part of a racket involving illegal removal and transplantation of kidneys from poor donors without proper consent or regulatory approval. Multiple victims filed criminal cases and civil claims against the hospital and the doctor and won compensation. Insurance company denied to pay compensation for the insured doctors. Another example, person with forged medical credentials posed as a doctor, happened in AIMS, happened in Safdarjung Hospital some time ago, and conducted surgery at a private hospital. Patient alleged medical negligence and won a claim. Insurance company denied claim of compensation awarded by consumer court. Now, why did indemnity insurance? My question to you is, why did the company deny the claim awarded to the patient? Why? Because it was a criminal act, or it was not a criminal act, or doctor should appeal as it was a wrong decision of the insurance company, or doctor did nothing wrong. It's for you to think. So, what is the answer? The answer is that it is a criminal act, and they are clearly excluded, or they're part of the exclusions of the indemnity insurance policy. Claims are denied if they arise from criminal activities such as doctor being convicted for an unauthorized organ transplantation. So, for example, a doctor in India. Okay, so this is clear criminal acts. Now, second one, a doctor attended a medical conference on the previous night. This is very practical, it has actually happened. Of patient surgery, consumed some alcohol and proudly posted them of his cheering with some drinks on Facebook. We commonly do it, The patient, nobody knows what is there in the glass. So anyway, the patient produced them in court in his complaint against the doctor for being irresponsible in his treatment and thus causing medical negligence. Patient won the case against the doctor, but the doctor's indemnity insurance company denied the claim. So he will not pay. So why did indemnity insurance company deny the claim? Why? Because doctor's alcoholism could have caused patient's death, or doctor did not offer alcohol to the patient, or intoxication of treating doctor is a bar to indemnity claims, or doctor should appeal as patient violated doctor's privacy. You could say, these are my private pictures, by using his photos without permission. So what is the answer that comes to mind? See, when you are posting this, just otherwise, I took this example on Facebook, they are no more private. You want the world to see. So you cannot claim that these are my private pictures and somebody is using them, patient is using them without my permission. That is one. But the answer here is intoxication of treating doctor is a bar to indemnity claims. It says that insurance won't cover claims where a medical professional performed a procedure while under the influence of alcohol or narcotics. It's very clear. Okay. So this was second exclusion. If you have a question, how many exclusions are there? Mind you, there are more than 30 T's. Okay. So it's very scary actually. Which of the following types of claims for medical negligence errors by doctors are not reimbursed by insurance companies? Now, mind you, there are more than one correct answer. Read them slowly. First is, which are not reimbursed by insurance company? They're kind of common sense. Breast augmentation. Second is nose reconstruction for cosmetic purposes. Third is nose reconstruction following injury. Fourth is mastectomy. And fifth is congenital abnormalities. I'm not familiar with this platform. Otherwise, I could have asked for a vote and answers through chat. But anything that is cosmetic. So the answer here is cosmetic procedures. Claims of cosmetic plastic surgery are typically denied unless it is for reconstructive purposes due to burns or traumatic injury. So the answer here would be breast augmentation and nose reconstruction for cosmetic purposes would be denied as they're purely cosmetic in nature, right? Nose reconstruction following injury, of course, injury has to be payable. Mastectomy, obviously, there has to be some, a medical indication for it, cancer, carcinoma, or whatever. Congenital abnormalities, obviously, they are also payable. So this was third. This fourth one. And this is very interesting actually of physicians, but we should also know it, because this is some of our colleagues or patients might be taking this. Which of the following drugs used for weight loss management causing medical negligence is not payable by insurance companies? So first is tirzepatide, second is semaglutide. Now I don't know how much you know about it, but
Answer is one.
let's come to the answer. So tirzepatide, see, we are talking about Indian FDA. Okay, we are not talking. That is the CDSCO, which is the counterpart of the FDA of the US. So in India, tirzepatide is approved for weight loss, correct? But semaglutide is not approved for weight loss. The question is about weight loss. It is approved for diabetes mellitus type 2. But till such time it becomes approvable by the CDSO, we cannot use it for weight loss. We can use it only for diabetes. But most physicians are using it for weight loss currently. हो सकता है 1-2 महीने में 6 महीने में whatever time में आ जाए, then it is okay, then the answer would change. But currently semaglutide is not approved for weight loss in India. In the US it is. Of course we have to follow our law. So if a doctor prescribes a banned weight loss drug leading to a patient, of course it can be you are जो weight loss के लिए आएगा, ऐसे patients हो सकता है कम हो, but the physician might be giving it for diabetes. But if he is writing on the prescription and the patient is non-diabetic that given for weight loss and is prescribed semaglutide, he's breaking a law. So if a doctor prescribes a banned weight loss drug leading to patient harm, the claim is likely to be denied. Now, there is a caveat here. Although this clause pertains to medical negligence due to use of weight loss drugs, but other drugs are also likely to be denied by an indemnity company as they are against legal or statutory obligation. Okay, because the company, see, just to harass you, they can say that this drug does not have a indication, approved indication as for whatever it should be used by the CDSCO. Hence, because they also have their own doctors who are looking into the details of the prescriptions. So the idea is that we should be using the drugs only for the indications that we have noted down in the prescription itself, not otherwise. Moving on to the next example. A doctor contracts HIV infection through accidental exposure and claims financial loss incurred in the context of HIV. So this just to make things more clear. He goes to court and claims loss. Now, who goes to court here? The doctor, not the patient. He goes to court and claims the loss suffered by him from his insurance company. Court grants कि ठीक है, doctor has suffered damage, in principle claim to the doctor. Now, what will happen out of the three scenarios? Insurance company will not reimburse the doctor. Insurance company will reimburse the damage suffered by the doctor, or insurance company will reimburse the doctor only if there is an allegation of medical negligence against the doctor. Any possible answers can I have?
Part C.
C.
Yeah. So, see, the idea behind this is that there should be an allegation of medical negligence by the patient against the doctor. It is not that doctor has suffered because of an accidental exposure to HIV. Okay. So it is the medical negligence component is mandatory. So claims, these are, by the way, all these pictures that I've used, I've generated them through AI after giving a detailed input. So these are all AI generated images. They are not available on the net. So, but all these exclusions that are there directly from the policies, and the which policies that I've studied four policies from the four state insurance company which I mentioned earlier: National, New India, United, and Oriental. And whatever I'm presenting is the common crux of exclusions of all the four policies. So claims arising from accidental exposure to HIV/AIDS are excluded depending upon policy specifics. Next one. A dentist performs a surgery under general anesthesia in his clinic. It results in complaint of negligence against him. Patient wins and is granted 10 lakhs by the court. Court claims the same from his indemnity insurance company. Now, what will happen? Insurance company will deny, insurance company will reimburse, or insurance company reimburse the doctor only if there was a qualified anesthesiologist and standard equipment available at the clinic. So I think the C option is self-explanatory here. So the policy says dental surgery performed under general anesthesia outside a hospital setting is not covered. Again, the indemnity insurance company might take the same plea for other procedures which you are conducting at your clinic and are not covered, and might be risky, and they may say that just like dental surgery, we will not allow this to be conducted at a clinic. You can do it only in the setting of a hospital only under general anesthesia. Okay, so this is just a caution for us. Next one, a hospital has outsourced. Now this is very common. Just a moment, please. Sorry. So this is very interesting and something very common. It might happen. I could not find a case law relating to this. Now imagine a hospital has outsourced laboratory services to Dr. L Path Labs through a contract. Of course, whenever you outsource your laboratory services, you are going to sign a contract between the hospital and the lab. A case of medical negligence is filed by a patient which involves a said laboratory in addition to the hospital because of some report, some fallacy in the reports. Court grants 20 lakhs to the patient to be paid by the hospital. Hospital claims it from insurance company. Now, insurance company will deny or will reimburse, or insurance company will claim it from Dr. L's Path Lab and give it to the doctor. So over here, simply the insurance company will deny the claim, and the company will not claim it from the lab and give it to the doctor. इसमें इस तरह का कोई provision नहीं होता है. Now why? Because please try to understand, the insurance will not cover financial liabilities that hospital voluntarily contracts with a third party, for example, a laboratory, without informing the insurance. So it does not mean that you cannot have a contract with the laboratory or with the, for example, entire ENT department or the ambulance services or whatever services. That means, but the idea is that you should inform the insurance company that you have a contract which will also be part of the hospital services and has to be covered by the insurance policy. The hospital insurance policy is called the error and omission policy. The indemnities policy, that is also indemnity policy, but that covers the entire hospital and staff and everything, equipment and laboratory and everything. But indemnity covers only the doctor. Professional indemnity policy. That means your indemnity policy is designed to cover your own legal liabilities only, not those that you have voluntarily taken on for others. So liabilities assumed by agreement, for example, hospital taking responsibility for a third party laborer, are excluded. Okay. So please remember, if you are running a hospital or standalone medical establishment and you outsource some of the services, please just inform the insurance company. And if they do not reply and you have the proof that you informed them, then and they do not object to it, then it is understood that they are going to cover it. Okay. Now moving on to next example. Due to an oversight, a doctor fails to obtain patient's signature on the consent form for a major surgery. Very common. Mind you, I've got more than 10 clients with this, patient signature missing. Doctors or the doctor's signature missing, patient signature is there. Doctor's signature is however present. Incidentally, due to a complication, the patient dies. Patient's relatives file a case of medical negligence. The court rules in favor of the patient and orders for a compensation of 35 lakhs to the patient's legal heirs. Now, insurance company may deny, may reimburse. Doctor's signature on consent form is not mandatory, hence claim is payable by insurance company. I'm sure by now we are all wiser that it is and hence payable by the insurance company. And the claim, sorry, the consent form, the signature is mandatory. So the insurance company may deny the claim altogether. Now, imagine, just I'm trying to supplement this. The question arises is that we are getting indemnified by the insurance company for the very basic reason that if an error or omission or medical negligence occurs from us during the treatment of the patient, then you, the insurance company, will reimburse the patient if the court awards anything to the patient, right? Now imagine something as basic as patient signature. It is an error or an omission, which is leading to medical negligence. So for the very basic objective that we got ourselves insured becomes the very basic reason for denial of claim. So this is very, very serious. For example, it says the insurance policies are designed to cover unforeseeable accidents, errors, or negligence, not intentional wrongdoing or blatant disregard for established laws and regulations. So the insurance company says this is an intentional wrongdoing. Now the question comes: how do you differentiate between a mistake, genuine mistake, and an intentional wrongdoing? Example 1: patient is harmed due to deliberate breach, for example, develops cancer due to excessive radiation exposure from faulty shielding, or burns while administering phototherapy to the patient or to an infant, and they file a claim against radiologist or clinic, the insurance company will likely refuse to pay. Same thing. Okay, because there is a breach during phototherapy, during radiation exposure. Second example, doctor is found to have intentionally. Can you read the slide? I hope it is not very cluttered or something.
We are
No,
able to
it's
read.
clear.
We are
Okay.
able to read.
Okay. Second example is doctor is found to have intentionally performed a procedure without proper consent, despite knowing it was legally required. It means that indemnity insurance covers negligence, errors, or omission without intent to harm, not intentional professional misconduct. It also means that if you fail to take care of all the requirements to maintain standard of care that is required as per Column's test, then the insurance company may deny the claim. So as I was trying to highlight, your errors and omissions or accidents, unforeseen accidents or negligence is seen as, in the affidavit they write that it is intentional harm or intentional wrongdoing by the doctor. So the very basic reason is lost for taking insurance. Another example, willful non-compliance, deliberate breaches or legal, the same thing, like statutory obligation, phototherapy दे रहे हैं, radiation exposure हो गया, okay, so it leads to claim denial, conscious disregard. Another example, court orders doctor to pay 20 lakhs for damage to reputation of patient. That is divulging illness of a celebrity patient. Okay, we have it. It has happened in the past, not once but many places. हमारे पास फला आया कोई सेलिब्रिटी पेशेंट या कोई मिनिस्टर और उसकी हमने इलनेस शेयर कर दी वीडियो में या किसी को, somebody uploaded it on the net. Now patient files a suit against this doctor, claims the same from his indemnity insurance company. The insurance company is not liable to pay, is liable to pay, or is liable to pay for all damages, whether physical, mental, or loss of reputation. What is your opinion, House?
क्या चीज?
C.
So ideally, this should be a scenario. Okay, this is what thought that they should pay for everything: physical, mental, loss of reputation. Now, before answering this, let us understand what are the components of compensation. See, this is very, very, very important to understand. Compensation does not mean कि court ने बोला 50 लाख दो, okay, and 50 lakh is the final amount. No, a standard components of compensation in a standard court order. What are the possible components it could have? When the court calculates. Number one, it is compensation for deficiency in service, which is the main component. Secondly, it is refund of amount paid by the patient to the doctor or hospital. Third component sometimes is compensation for mental agony, harassment, or loss of reputation. You might have by now read so many judgments which say and 50,000 rupees and 20,000 rupees, although it is a small amount in comparison to compensation for deficiency in service, or 1 lakh rupees or 2 lakh rupees, if it runs in 50 lakhs or 1 crore, granted for mental harassment or agony or loss of reputation of the patient. Then fourth component could be litigation cost. ये भी कोर्ट बहुत कॉमनली ग्रांट करता है, although that is a small part. Then interest on compensation from date of filing suit. Now, this is sometimes more than component number one, which is compensation for deficiency in service. Sometime in the Kunal Saha case, the compensation was more than the principal compensation awarded by the court. 5.5 and more than 6 crore, total almost 12 crore. So because that interest is, if at the common rate of 6%, it might run into 10 or 15 years. So 75%, sometimes even 20 years. So 200% 6% multiplied by 2, 120%. तो यही हो गया अगर 20 साल केस चला सुप्रीम कोर्ट तक गया तो 120% ऑफ द ओरिजिनल अमाउंट यू कैन इमेजिन वो कितना हो जाएगा मोर देन डबल यू नो punitive damages or fine, it is separate, it is not compensation. So there are almost 6 components of compensation we have to understand. And insurance company simply says that we are not liable to pay anything more than the first two. I have highlighted it in, colored it in green. First two components, deficiency in service and refund. The red means not payable. Loss of reputation, mental harassment, litigation cost, that is the advocate's fees, interest on compensation, punitive damages or fine, they are simply part of exclusions of the indemnity policy. For example, I have listed out example. For a usual consumer court order may have the following components of compensation. Compensation for deficient service 20 lakhs, refund for example 4 lakhs जो उसने पेशेंट ने एक्चुअल दिया ट्रीटमेंट के लिए उसका ऑर्डर किया रिफंड कोर्ट ने कंपनसेशन मेंटल एगनी और हेरेसमेंट और लेस ऑफ रेपुटेशन 2 lakhs लिटिगेशन कॉस्ट 1 lakh ये भी स्मॉल कंपोनेंट होता है इंटरेस्ट इज at the rate of 8%. Sometimes court gives 6%, sometimes 8%, sometimes 7%. कोर्ट का भी अपना मूड चलता है ये कोई फिक्स नहीं है अंडर लॉ For 6 years, it amounts to 11.52 lakhs on 20 lakhs. Okay, that is 48%. Punitive damages or fine 2 lakhs. So total comes to 40.5 lakhs. So original compensation was 20 lakhs. So ideally, insurance company will pay only 20 plus 4, that is 24 lakhs. The rest about 16 lakhs, doctor will have to pay from own pocket. Because they are part of 3, 4, 5 and 6 and insurance company pays only 1 or 2. So this is very, very scary. So financial loss only if, for example, in a particular case the court does not award anything but awards only compensation for loss of reputation or goodwill, then that is totally excluded from the policy. Personal injury like defamation, doctor says I was defamed, libel is verbal, slander is written defamation, or mental anguish without any direct physical injury, they are excluded. And by the way, these are only for the patient, not for the doctor. If the doctor claims I have been defamed by the patient on social media, then he will have to file a civil suit. It is not covered by indemnity insurance policy. He will have to file a civil suit in a civil court. It is not got anything to do with Consumer Protection Act or consumer courts. So that is doctor's defamation, doctor's injury is totally different from this. We are talking only about patient's injury due to medical negligence, damage caused to the patient due to medical negligence. So punitive damages, again, fines, penalties, totally excluded from insurance policies. War or nuclear risk. So if there is a war, damage suffered by a hospital during civil unrest, war or nuclear incidents are excluded from indemnity policies. There could be a riot outside the hospital which causes damage to the hospital. They are excluded. Pandemic laws. We know the COVID pandemic is a fresh example. Many policies exclude losses, injuries, or liabilities arising directly or indirectly from pandemics or epidemics, as well as violation of related acts. Genetic injuries. Claims alleging birth defects from excessive X-ray exposure or radioactive substances may be excluded by the insurance companies if they are able to prove it. Pre-retroactive. For example, incident happens on 30 September. Now you quickly, 1st October, today you take a policy and the patient files a complaint, let us say after 2 months after the incident. Now you go to the court that I got myself insured much before the patient filed a case. The cause of action is not the complaint. The cause of action is when the patient discovered that cause of action. The patient discovered that there was negligence, and that usually starts with the first consultation itself. Okay, so pre-retroactive date, negligence occurring before the policy's effective date is generally not covered. And injury to employee, they are not covered by indemnity policies. They are covered by hospital error and omission policy. Late notification. There is a case law that I'm going to cite for this. Failing to report a case immediately. Mind you, the word is immediate. It is not about 1 month or 2 months later. They've got a right to refuse if you report it late. You have to report immediately or as soon as reasonably practical after receiving notice can lead to denial by the insurance company, because doctors are so busy. In they'll say कि ठीक है स्टेट मेडिकल काउंसिल का आ जाए उसके बाद अगर कोर्ट जाता है तो करेंगे, but then it has already taken about 1 year or 2 year, so that is already late. The insurance company is within its right to refuse the claim. So you have to report immediately upon receiving a notice by the patient. Do not have to wait a legal notice from the patient's advocate. Unauthorized admission of fault, for example, admitting fault or settling a claim partially without the insurance written consent, can invalidate indemnity coverage. So, settling a claim or complaint from a patient out of court by doling out a sum of money or hush money to the patient's family may be advisable by many colleagues in the profession, as commonly seen. But if the patient later complains to the court about it, then in the defense, the doctor would reply in the court that he paid settlement money to the patient. In such a case, the insurance would deny to pay the claim if awarded by the consumer court. So if a claim is settled, it should be done with the court's approval. Now they have mediation cell within the court premises or with a not to sue covenant. We have done it for many of our clients. Not to sue covenant, that the patient will not sue the doctor if he is given a some settlement money. So if he sues, then it is not 100% not to sue covenant is not 100% safe umbrella for a doctor, but it is like it works like 90-95% cases. It is safe for the doctor. So whatever so-called out of court settlement has to be done, it has to be done with the approval of the insurance company and with the court of approval. So it is a misnomer to call it out of court. It is actually within the court's approval. Yes. So non-cooperation. If you refuse to share case documents or help in investigation, defense of a claim can lead to denial. I mean, insurance company is asking for the case documents, and you say that the case documents are with the police, they are with the court. So take it from. No, you have to give us a copy if they ask you for it. So misstatement or non-disclosure, providing missing, incomplete, or false information in the application form for indemnity insurance with the company or claim documents can lead to policy cancellation. For example, if you've had a previous claim and you file a fresh application with the insurance company for a indemnity insurance policy, and in that you do not disclose that you had a previous claim, and if the current insurance company comes to know about it, they can deny the claim, just like motor insurance claim. Fraudulent claims filed with forged records or fabricated case files are considered fraudulent and will be denied. So अब इसमें देखिए बहुत ही important चीज मैंने बोली है. So overwriting, false entries, manipulations, entries in different ink, entries in different handwriting, pages inserted with different handwriting, where the intention is to do all this may have been to defend against the patient's complaint. But if the insurance company court finds it, the insurance company will find it, or the insurance company on its own investigation can deny the claim. So we are commonly doing it, but it has to be done in such a manner that everything has to be presentable and genuine in front of the court and the insurance company, because now the litigants are not is not only one, the patient. It is the insurance company also which is the litigant, and you have to fight against two, the patient and the insurance company, to get your claim. Failure to sue in time, already talked about it. Now this is the last one. Policy limit, AOA versus AOI. AOA means any one accident, and AOY means any one act. Now, this refers to pre-occurrence limit, that is the maximum amount the insurance company will pay for any single claim or incident, that is any one accident, AOA, that occurs during the policy period, regardless of the total number of claims in a year. So this limit applies to one specific event of negligence or error. Any one year means this refers to annual aggregate limit, that is the total amount covered of the insurance policy. It is the maximum total amount the insurance company will pay out of all covered claims that occur within a single policy year, regardless of how many individual claims there were. Once this limit is reached, the insurer is not obliged to pay for any further claims within that policy year. Now, you have to give this at the time of filing the application form. So AOA to AOY could be 1:1, 1:2, 1:3, or 1:4. You have to choose one of the four options. For example, if you choose 1:4, and you have a policy for 1 crore, then the maximum amount payable for one claim is also 1 crore for 1:1. If you choose 1:4, that means the maximum amount claim per claim is 1/4. So 25 lakhs. For 1:2, it is 33.3 lakhs. Okay. So it goes similarly. So so I'll take up the case laws, then I'll talk further. So there are only two brief case laws. First is Dr. Sanjeet Singh Grewal versus National Insurance Company of National Commission 2015. The doctor was held liable for 4.23 lakhs. Just a moment. Just sorry. So this is National Commission case from 2015. Facts were the doctor was held liable for 4.23 lakhs in compensation by District Forum for negligent treatment leading to patient injury. He filed a claim under his 3 lakh professional indemnity policy renewed since 2001. So grounds for denial were by the insurance company. The insurer said the insurance company repudiated the claim due to doctor's failure to notify them immediately upon receiving the consumer summons, breaching the policy's immediate intimation clause, and preventing insurer involvement in defense. So the court said that NCRE partially overturned the full denial, attributing the lapse to ignorance of policy terms, as only the schedule was provided. It directed payment of 1.5 lakh as against 4.23 lakhs ex gratia, but upheld the principle that non-compliance justifies repudiation, that is, reversal or cancellation of the policy, cancellation of the claim. Second case law, New India Assurance versus Consumer Education Research Society, 2017, also National Commission. Patient suffered complications and permanent disability after a botched orthopedic surgery at a private hospital. State Commission awarded 15 lakhs against the hospital and surgeon. The hospital sought reimbursement under the surgeon's professional indemnity policy. Grounds for denial by the insurance company were that it was excluded for gross negligence as found by the Consumer Forum, and the policy covered only errors or omission in professional act, not willful or culpable negligence. So court's decision was the NCRT upheld the denial, confirming that proven gross negligence triggered the exclusion clause under the Insurance Act. The insurer was not liable, leaving the doctor and hospital to bear the cost. So it means that the policy is, error and omission policy, as I said, is for medical establishments. It is a hospital policy. But the same principle also applies error, omission, or accident negligence. The same principle also applies in doctor's professional indemnity policy. So sometimes if there is gross negligence, then also it becomes a ground for denial by the insurance company. Again, the same principle has been violated, that I obtained the policy for negligence. Now that becomes the very basic ground for denial. So to summarize, understand your policy's exclusions thoroughly. I've talked about almost 30 of them. Adhere strictly to policy conditions, especially regarding notification and cooperation. Be aware of your financial limits and any excess that apply. Always disclose all material facts during application and seek legal advice if your claim is denied unfairly. Okay. So, uh, last word. Yeah. Just let me stop sharing. So the last word is that having said that there are so many scary exclusions, I would say that in such a case when the insurance company denies the claim, what practically happens? See, courts are I would say very lenient towards doctors. They help the doctors, and they force the insurance company to pay up, despite there being clear-cut exclusionary clauses in the policies. The court says that insurance company, you have to reimburse the doctor and pay the patient. Okay, in most cases this is the scenario, although I have tried to picture it as if it is very very draconian, but take it with a pinch of salt. It is draconian, I would still say. And the court helps the doctors in compensating the patient. But in many, these are only two case laws that I told you. There are many more examples where due to so many reasons the courts have, the insurance company is simply denied to pay 50 70 lakhs rupees that I know of. Maximum is 70 lakh rupees that I know. So doctor has had to pay from his own pocket. But now what is the increasing trend? Earlier the insurance company used to pay up. Now they, since the premium for the policies has remained the same for almost 25 years, they've not increased, and it is still very very peanuts. So there is a lot of burden on the insurance company to pay up. So they are increasingly denying the claims. This is the recent trend. Okay. And now very last part about the policies, which many people recommend that you take 2 or 3 policies. I am also in the favor that when you are showing the court that I've got a policy of 2 crore rupees, so courts are very lenient in granting claims in favor of patient. So it would be advisable that you take a policy of 50 lakhs and maybe another one for 75 lakhs, another one for 75 lakhs, or another, or maybe 50 lakhs and 1.5 crore. And from the same company, not 2 different companies. What is the logic behind it? See, when you are taking from 2 different companies, that means in the court, when you are giving your written statement, you are going to inform 2 different companies that I have a policy with you and I have received these summons and legal notice, and hence I am filing a reply to the court. So you have to make 2 more parties other than the patient, the insurance company 1 and insurance company 2. They both will the parties. और अगर एक के साथ 50 lakhs का पॉलिसी है, दूसरे के साथ 1.5 crore का है, so obviously the court has to it is in the eyes of the court. But अगर same company है, because I talked in detail about this to an insurance company, they said अगर same company है and you are divulging only one policy of 50 lakhs and not the other one, then it benefits the company also. That is why they are keeping quiet. And they are not saying, sir, the doctor has a policy of total 2 crores. So they are keeping quiet till the end. And in case a liability arises for an amount which is more than 50 lakhs, which was divulged in the court, then the insurance company will say, okay, we'll pay now. They cannot say doctor did not inform the court about it. The insurance company says that whatever happens between you and the court is separate from what is the contract between me and you. Hence, I will pay on your behalf. So, if there are any questions, I'll be happy to take.
Yeah. A beautiful, beautiful, wonderful talk, Dr. Gaurav. And I think many hidden points were made clear out of your talk that we were not aware of. Now, my question, my one point is very true. What you said, that we have to fight with 2. One is, that means you mean to say that our replies should be focused, based, keeping in mind the insurance company also.
Yes, absolutely. But only for those, see, as far as the insurance company is concerned, Insurance companies part of every date that the proceeding is going on. They receive the notice as well, just like the patient.
Okay.
Okay, so they are supposed to appear, but they see what is the proceedings going on. So till such time it does not affect them directly, they don't appear purposely. But when the matter comes to pay up, then they come with a written statement that no, we are not liable to pay for these 10 reasons.
So,
Okay.
but secondly, can court direct them to pay?
Yes, court has that power. And see, if they are, I gave two examples. If they are categorically covered under the exclusions of the policy, then by law, court cannot direct them to pay. But under the court has, these powers to direct them to pay, and in almost all situations, uh, the insurance company does pay up. That is the practical situation. But you see, the increasing trend is not to pay. The court, if the amount is more, for example, 1 crore, 2 crore, the insurance company, despite court's direction, will appeal to a higher court. We are not liable to pay. They'll go to state commission, they'll go to national commission, they'll go to Supreme Court. No?
And last, my question from my side, that gross culpable negligence is amounting to criminal negligence, you mean to say?
Yes, yes, yes. But the criminal part is apart from the consumer. But the word here used is gross.
Gross.
Okay. So yes, in the criminal sense, but the consumer court has got nothing to do with the criminal aspect. But if the word gross is there, the court rules that there was gross negligence. Then the insurance company says that it was for error and omission, an accident, and that gross is not error and omission. Gross is much more. So they, tend to escape from paying up.
Thank you. Yeah. Dr. Sangeeta ma'am, thank you for asking questions. I will request Dr. Sharlajan madam has logged out.
Yes, ma'am. She is not here.
Yeah. Ma'am, Dr. Ragini, can you just give your expert comments?
Thank you, Shakuntala. It's a really eye-opener session, and we all gain a lot from this today's session. Specifically, we should have a two policy and from the same company. That is I think the most important message is given by Dr. Gaurav. क्योंकि ये जो बात है ना कि हम लोग 2 करोड़ की पॉलिसी ले लेते हैं तो अपने आप ही अपने गले में फंदा डाल के बैठ जाते हैं. तो ये एक बहुत ही आपने सही बात बताई है.
And one should be smaller amount, like 50 lakhs.
One is smaller amount and one bigger amount.
Yes, which you can conveniently hide from the court, because if the company say it is not hidden from the company, it is hidden only from the court and the patient.
हाँ मतलब आपने खोला नहीं है, आपने
It is
छुपाया नहीं है और
strategic.
खोला
Yes,
नहीं है.
exactly. It is strategic actually. It is not a
It's a
lie.
strategy.
You are saying that the so and so insurance company is liable to pay. You are
Yes.
lie. बाद में कोर्ट कहता है तो आप बोल दो कि साहब ये भूल गए थे, रह गई थी. Or anyway the company is liable because the company cannot say. See, ultimately matters is company ka denial. The company
Yeah.
cannot say no because they know that so and so doctor, despite having showed only one policy, is covered with 2 policies.
I think it's a very important message which today is given by Dr. Gaurav, along with other things also, because once we never think about when we take the policy as a doctor, we don't apply our mind on these things. I think this is a very important points. When we take a policy, we should discuss everything specifically.
So
If
I'll tell you
anyone have
another
a staff-
practical thing. See, if you already have a single policy of 2 crores, no, you don't need to change it. Take a smaller policy of 20 lakhs or 25 lakhs, for which the premium will be, hardly 1,000 rupees or, 800 or 1,200 rupees. So you can continue both of them, and when the need comes, you show only the smaller policy and keep the bigger one for reserve. That will continue as such.
Thank you.
Thank you so much. Thank you so much for your time and
Thank
your
you.
sharing your knowledge, doctor. And your slides are extremely beautiful also.
Dr. Vidhu Mudgil, welcome to our NITF Community Pathshala. And I'd like to have your expert comments.
Thank you, NIGF, Dr. Sharda ma'am, Dr. Ragini ma'am, and Shakuntala for inviting me for this talk. Once I thought कि ये मैंने कभी सुना, मतलब पढ़ते तो नहीं, हम तो सिर्फ बुला लेते हैं और करवा लेते हैं. But after, when you were supposed to come to this session, so you read about it, something you will know. But this session was definitely an eye-opener and lots to learn. Thank you, sir, for your enlightening talk. The only thing I also liked about one thing what Dr. Agini also said, that we should have two policies. And second thing is, whatever policies we have done, we should also we have partnered with some labs and all. We should tell the insurance company, which we sometimes forget to do it. We generally don't do in a smaller units. So that's another eye-opener message I have taken for myself at least. And I think so this initiative is really good. बाकी तो हम सब सुनते रहते हैं मेडिकल सर्विसेज, बट ये चीजें हमें बिल्कुल भी आउट ऑफ वी आर आउट ऑफ बाउंड्स ऑफ थिंग्स. एंड thank you so much for enlightening us on this. Thank you, Shakuntala, for inviting me.
Thank you, Dr.
Dr.
There is a
Gaurav,
question.
I have one more question, Dr. Sakula. Is the same thing applies to CT, MRI, and other radiological investigation as you said for the lab reports?
If there is a separate contract with them, then only. If they're part of the hospital management is the owner, then there is no need to inform them. By default, they're part of the hospital itself. If you have a separate, contract
Yes.
with somebody who's providing radiological services, then you need to inform your insurance company about it.
Sir, there is a question.
And then other thing is,
Sorry.
Yeah, please.
another thing is for fertility also, are these insurance liabilities there for fertility, for IVF and fertility?
Yes, it is for everything. Anything that can cause result in medical negligence, insurance liability is same.
Right.
Sir, Dr. Gaurav, if
So there also we should have two policies.
Sorry.
So sometimes there are visiting consultants who just come and operate.
Mhm.
So how do we go?
So just ask.
Is the hospital responsible for them?
So first of all, visiting consultant, part-time consultant, courtesy consultant, and this and that consultant, full-time, the liability is equal. Number one. Number two, they are not covered as part of hospital error and omission policy. Only hospital owners, like directors, partners, they are covered under hospital error and omission policy. Number three.
Right.
Having said that, if they are visiting any other hospital other than your own hospital, then even the directors, partners, or owners need to have a separate indemnity policy. And lastly, every visiting consultant, courtesy consultant, part-time consultant, full-time consultant needs to have a separate professional indemnity policy. They are not covered by hospital error and omission policy.
So we should, once we make a contract with them, so we should write in there that they're not covered under hospital policy. Is it?
There is no
so?
need. It is understood. You just write in that contract that you are required to produce a valid copy and submit every year a valid copy of your indemnity policy to the management.
Right.
Sir, there's a question from one Dr. Indu which says, please opine about cover you insurance through Foxy.
So, see, if Foxy is doing something, I'm sure, by default, they must have taken care of most of these aspersions that we are talking about today. And if they have not, I don't have a policy. If you share it with me, I'll be able to see the weaknesses and strengths of the Foxy policy with Cover You. So I don't know what is happening between them. I will not be able to comment, but yes, there are good organizations who have tailor-made their policies, like the AMC of Mumbai. Their policy is very strong, and it is very starkly different from what the insurance companies are offering to us directly. Because they are going in as a group, they are paying more than crores of premium, more than 50 or 100 crores per annum, because they've got more than 15-20,000 members. So for that much amount of premium, no insurance company will say, deny the claim. So their policy is very different and tailor-made according to their demands. And what my vision is that we should talk to, yes, Dr. Aarti, we should talk to the IMA Yeah.
I just wanted to share that this Cover You policy is through ICICI Lombard. And whenever we are going through a group policy, the kind of money that you need to pay as indemnity is also lesser. It is very difficult for the company to deny because a lot of doctors are involved. Then they will not take up the policy. So it is a very good policy to be taken when it is going through a group, because the amount of indemnity which you need to pay is less. I just wanted to, Dr. Saab, add one more case to this, that there was a case of ophthalmology where the doctor was penalized with a lot of compensation, and he said, no, this was not my negligence. And it was due to a reaction of the drug. And because of this aspect, the insurance company refused to give the payment because they said, we are covering an error in omission, we'll cover your negligence, but we will not cover the allergic reaction to a drug.
All accidents, see, service policy is covered. All accidents, errors, and omissions are covered. So, having said that, yeah,
in that the drug reaction was not covered. Any reaction to the drug,
it is
which
an
was
accident.
in the eye, yeah.
It is an accident. So, I don't know. Accident word is clearly written in the policy.
No, but the court granted compensation in this accident.
The court granted compensation. The doctor had to pay from his own pocket. The insurance company refused to pay.
So,
And coming back on the
But
part
ये
of
नहीं समझ में आया
discounts.
reaction के लिए क्यों
मैं
negligence
अगली बार
grant
इस केस का आपको नाम भी साइट कर दूंगी.
So coming
I have
back to
this.
the discounts, as I said, कि 60% discount तो सभी दे रहे हैं, but the idea is to see what the cover you policy is. Is it the same policy? Because see, cover you is not the insurers. ICICI is the insurer.
ICICI
what is the-
Lombard is the insurance.
So we will have to look into the policy of ICICI Lombard versus maybe versus all these exclusions. If these exclusions are there, and today, for example, they are paying, okay. Tomorrow, if they say no, we can't do anything because it is written in their policy clause. So we will have to go about each and the power of doctors of a group is only when we can have dictate our own terms and conditions of the policy and have all the exclusions as far as possible removed from the policy.
Yes, sir, we have to pay a very low amount for cover you. It's, I think, around 6,000 to 8,000 per crore.
It's the services that we are looking for, and people are willing to pay maybe more, double, triple. That is immaterial. We'll have to look at the policy wordings. How are they same as state insurer policy, or they are different? If they are same, and I personally would not like to see the discount. I would like to see if the policy wordings help me. Then, and if I have to pay more amount for that, I'll probably go for that. That is my take.
Sir, I have a New India
Okay,
insurance. Okay, fine. Please go ahead.
Please go ahead. Yeah, Dr. Aarti, please go ahead.
Yeah, I have a policy through New India Assurance as well as Cover You, and they do not provide you lawyers. The amount is 3 times that you pay in Cover You. It is a 1:1 policy, both of them. But if you go ahead, the discounts are major in Cover You. I'm not going for, I'm not advising anybody to go for Cover You. It is their own choice. But this is what I have taken for myself.
Going ahead, our vision should be that Foxy and IMA at some level. Yes. I don't know, because I'll have to read. I mean, if you, Dr. Shukla, Dr. Sangeeta, if you have the policy document, please share it with me. I'll go through it and compare the policy. Because the idea is that we should be able to negotiate with them, as Dr. Aarti said, for all the exclusions. That is the idea. And IMA and Foxy, we should all work together so that we can have our own policy designed and work upon and take it for all of us. All right. You are muted, ma'am.
Anybody has any questions after this? Does anybody have any questions? Sir, I have one question, and that is, suppose there is an owner who owns a lab by a different name, right? And here the hospital is owned by the owner completely, but the lab is owned by some partner as well. So he is partnering the lab. Then also, and all the lab services are like outsourced to the lab. Then also the insurance company has to be like duly informed about this.
Oh, yes. Because
Collaboration.
if you have a separate contract with them for the lab services,
Ji.
then you need to inform the insurance company. Otherwise, if there is some negligence which is incriminating the lab, the insurance company will refuse to pay on behalf of the lab.
Oh, right. Should I conclude?
Yes, ma'am.
Yes, I think.
Yeah. So thank you very much, Dr. Gaurav Agrawal. It was really a pleasure, as always, listening to you and all the experts, Dr. Shardajan Madam, Dr. Sangeeta, Dr. Ragini Agarwal, Dr. Vidhu, Dr. Aarti. I fail to see how many more have joined, but then thank you everyone for joining. Some takeaway messages. Indemnity insurance is a shield. It definitely protects doctors from financial and legal consequences. There are some exclusion criteria we should know before signing the contract. For example, all contractual relationships with the third party like a lab has to be informed to the insurance company. The exclusion criteria like war, pandemics, violence, etc., are to be looked into whether they are excluded from the paid compensation when there is any need. Then the insurance company cover more than compensation. They include legal defense, court costs, and settlements. Also, policy has to be tailored. Coverage must cover and match specialty, risk profile, and place of the practice. And consent clause does matter. Keep all the coverage updated, review and enhance your indemnity cover regularly as your practice is evolving. Peace of mind, of course, is most important as indemnity insurance allows doctors to focus on patient care without constant fear of litigation. I thank you all for your patient listening. Thank you very much.
Thank you, ma'am.
I think. Thanks,
And
Thank you, Divan.
thanks, Mr.
and
Roshan,
I
for
thank you
providing
all
us
for
this
the
platform.
patience, your patience.
No, we are sure that it will be smoother next time.
Yes,
Good
yes,
job.
sir, definitely.
No, we will work for it. Maybe we will
So then go and look into
have
our policies and then contact you and ask
we
you
will
what is
evaluate
good.
another platform.
Yeah.
Dr. Gaurav, it was a beautiful, beautiful talk. It was
Thank you.
really very concise, to the point, and understandable. What
Understandable.
you
That's
showed
important.
us was it directly went through the mind, and we
And the
could
MCQs were very, very interesting.
Ah.
No, you made the whole talk very interesting and different.
So I made it all from my mind, and but the AI images, I am thankful I could generate them. It took many days, but I was able to do it.
I think we will need this.
More practical oriented, what
Yeah.
you need actually to know.
Thank you,
Thank
Dr.
you very
Gaurav.
much.
Thank you. Thank you.
Thank you so much.